South Africa's National Police Commissioner, General Fannie Masemola, is reportedly facing criminal charges over a 360 million rand police health services tender awarded to businessman Vusimuzi Matlala. At least 12 senior police officials linked to the contract have already been arrested, with Masemola due in court on the 21st of April. Earlier this year, advocate Paul Hoffman from Accountability Now made a plea before South Africa's Parliament ad hoc committee investigating police corruption, urging the establishment of an independent body in line with the Constitutional Court's Glenister 2 judgment. He joins us now to discuss the legal implications and the broader case for independent oversight. Professor Advocate Hoffman, thank you for joining us, and good morning to you.
Thank you for that fulsome introduction too. Good morning to you.
Our pleasure, and we appreciate you making time. So, Advocate Hoffman, how serious are these charges facing General Fannie Masemola and the other senior SAPS officials linked to this Medicare 24 tender?
Well, we must all remember that they are presumed in law to be innocent until proven guilty, and that the onus is on the state to prove beyond a reasonable doubt that all of them are indeed involved in the tender rigging and corruption that we have heard so much about during the proceedings of the Matlala Commission of Inquiry, and also in the ad hoc committee of Parliament, which has just finished receiving its evidence last week. So assuming that guilty findings are made in the pending criminal cases, not only against General Masemola, who's only going to appear for the first time on the 21st of next month, but also against the other 12. I think 11 of the 12 are police officials and one is not. So let's not run ahead of ourselves. Let's allow the law to take its course, and let's wait until there are verdicts in criminal cases before we assume that those charged are indeed guilty of the charges. There seems to be a great deal of evidence against them, and that being the case, the prospects of success in the criminal cases are good. That being so, what is South Africa meant to do about it? Well, we've heard a lot of evidence in Parliament and in the Matlala Commission, which suggests that the police are in deep trouble because of the rot, the corruption that seems to permeate every corner of the organization. There's a suggestion from General Masemola, who blew the whistle on the police, that there are too many generals in the police and that the number of generals should be cut down. We've also heard a UCT academic, Irving Kines, suggesting in public that all of the generals in the South African police service should be fired. They should have their services terminated. And those who think they deserve to have their jobs back could then apply for their jobs, go through rigorous pre-employment testing, including lie detector tests and lifestyle audits, with a view to determining whether they are fit and proper people to be re-enlisted in the SAPS, and in that way do a quick and efficient clearing of the corrupt individuals who are among the leadership in the police. There's
On the
also
point
another
you make of
suggestion
let's
that
allow the law to run its course, how does the law usually establish accountability in cases like this where top police leadership is implicated?
yes, it's a criminal trial in which the charges that are preferred against those involved are subjected to the process of cross-examination, and finding the truth of the matter. And if the truth of the matter is that there has been corruption, then those found guilty will have to suffer the consequences of the guilty finding in a court of law. Of course, it's also possible to start a labor law consequences for those implicated, and there, which is what happened with General Pashlani, who has been litigating his dismissal from the police because of his involvement in corruption. That case is just dragged on indefinitely, and it seems that he remains in denial that he did anything wrong, but he is no longer a policeman because he has been terminated in the labor law sense of the matter.
You previously made a plea before Parliament's ad hoc committee, advocate, for an independent anti-corruption body. Why is such a body so important in cases like this, and how would this work?
Yes, the decision of the Constitutional Court in the Glenister litigation, to which you referred very kindly in your intro, is that a body outside the control of the executive branch of government is required to deal with corruption effectively. And that we don't have yet. It hasn't, that judgment has never really been translated into the enforcement of the rule that the anti-corruption machinery of state should be outside the control of the executive. When we started the new South Africa, we created one prosecution authority and one centralized police service in place of the South African police force, which was an authoritarian body that was there to look after the state rather than to be the friend of the public. So that transition from a force to a service has never been properly implemented, and we still have police bearing military ranks as though they are a force, when in fact they should be a service. Now, to implement the Glenister case, it will be necessary to create a new body that is not under executive control, and we have suggested that the right place to put that would be under Chapter 9 of the Constitution, because the architecture of Chapter 9 is such that we do not have any involvement of the executive branch of government in any of the Chapter 9 institutions. Now, to get to that point, you're going to have a constitutional amendment, and you're going to have enabling legislation, both to establish the new body outside executive control and to give it its legislated mandate. That has yet to occur, but once it does occur, you will get a situation where corruption matters are dealt with by a body outside executive control, and that specialized body of trained operatives who are independent of the cabinet and who are secure in their tenure of office and properly funded will be able to get on top of the corruption, not only in the police, but in politics and elsewhere in South Africa. So that plea is still on the table. The ad hoc committee will deliberate on it. One of the members of the ad hoc committee, Advocate Glenister Breitenbach, who was the Shadow Minister of Justice in the last Parliament and is now a chair of the Constitutional Review Committee, will be punting her bills, which envisage what she calls an anti-corruption commission under Chapter 9 of the Constitution. So her bills have been on the table in Parliament since November 2024, and nothing has come of them so far. But the workings of the ad hoc committee and the Matlala Commission may well provide the necessary political impetus to generate the political will required to reform the criminal justice administration so that corruption is dealt with more effectively and efficiently.
Advocate Hoffman, let's leave it there. We are completely out of time, but we really appreciate your valuable insights and analysis on this matter. Advocate Paul Hoffman SC, Director of Accountability Now, sharing his insights there on the unfolding Medicare 24 tender scandal and the broader questions around accountability and corruption within the South African Police Service. Our time now, 7:31 Central African. Let's say good morning to Onele Nsinzi for our news headlines.
SABC News. Headlines. The African Perspective.